Acting Judge Sean Snyman dismissed Bemawu's urgent application to retract redundancy letters issued to employees. The union had brought the application because it said management had gone ahead with retrenchments in the middle of a consultation process. But in a turn of events, the SABC announced last week that it was placing its restructuring process on hold to allow further consultation.
We are satisfied at this point in time on how that consultation process is going ahead. This is what we have been asking all along from the beginning. And we think that it was utter bad faith on the side of the SABC. Every time that we enroll the application, they extend. They say they're going to consult, and then staff are issued with termination letters. When we re-enroll the matter, suddenly there comes a letter that says we are going to extend.
Bemawu has described the Labour Court judgment as disappointing, but says it's not the end of the road as it may appeal. The union believes that Justice Snyman may not have fully understood the application pertaining to a flawed consultation process.
The court has said in the brief scanning through the judgment that we did not put the entire consultation process and all of those minutes, which we did request from the SABC and they never provided to us. We did not put that before the court, and we think that on the basis that the court did not have that particular record of the consultation process, that it came to the finding that it did.
The SABC has welcomed the judgment and dismissed Bemawu's claims that management has only now started consulting. Management accused the union of misrepresentation and using delay tactics to undermine the process.
After 4 months of consultation, Bemawu had still not come to the point of providing alternatives. So they used delaying tactics and unfortunately negatively impacted their members. So we are now opening that process up to allow all staff to participate in this process and say, give us your input, because we can't trust that Bemawu is going to do that.
The union has vowed to return to court if members are unhappy with how the process unfolds. Mbalenhle Mthethwa, SABC News, Johannesburg.
All right, let's speak to the SABC's Chief Operations Officer, Ian Plaatjes. You saw him there. Mr. Plaatjes, thank you for being with us. Part of this court finding was on the process thus far, the consultations, and it found in your favour. But your response to what Bemawu said in that insert, that it couldn't prove its claims that these meetings during the consultation period were hollow because the SABC didn't provide information to the court, important information like minutes of the meetings.
Thanks, Francis, and good evening to your viewers as well. Once again, Bemawu is misleading their members and misleading the public. That is not true. So the court found in our favor, this is not a victory for the SABC. The process is still continuing. From an SABC point of view, we always knew that the process would withstand any legal or moral scrutiny. So the Bemawu has got all the recordings of every single meeting that we had, 16 sessions, 7 facilitated by the CCMA. They had that. They could have given that in as evidence. They could get transcripts of that. So I fail to understand what they mean by that.
All right, this is a court victory, but is it a moral victory? Just looking at what came up in Parliament yesterday, and we've heard this said again and again. Of course, parliamentarians disagree, the parties disagree, but SABC is in a financial predicament. But the question is, was it just too easy to look at retrenchments as the first option? Did you, as part of a new management, just come in and say, let's not be innovative, let's just start cutting stuff? Was that all too easy?
Definitely not. So you know that we have a GTAC report and they developed the strategy for the organization. That is some time back already. Part of that strategy was a cost reduction in staff numbers. Now, if you look at it, that was developed last year already. We are executing a strategy that was developed not by ourselves, We fully support the strategy, though. So it's not the new management coming in and this is an easy answer. The strategy doesn't only deal with a staff reduction, it deals with cost reduction. So there's other aspects of it as well that we're looking at. And certainly it deals with revenue generation as well and new revenue drivers. So it is a holistic one. It's not just targeting staff.
Can we look at where we are now? So you've committed to engage further with staff because the majority of the staff weren't involved in that process. You're now consulting with these staff members, but you're not withdrawing the redundancy letters that have been issued thus far.
That's correct, Francis, and the court has found in our favor that what we are doing is correct as well. So let's just understand the process. During the 189 process, the unions represented their members and non-unionized employees were represented by a group of people that they discerned. During that process, we were consulting on all matters, and we should have reached matters of the structures as well as matters of alternatives. Unfortunately, due to the delaying tactics, we never got to that point in time. When the 189 process was terminated, management then had a right to execute on the retrenchments without having consulted with anyone else further. But we did not do that. We further consulted with other stakeholders as well. In that engagement, staff actually mentioned and said, but you know what, you never spoke to us. We explained that the process, the rules of engagement was via the unions and their representatives. However, what we then undertook was that we would engage them in the structures as well.
Okay, Mr. Plaatjes, we're running out of time. I understand what you're saying, and you have said that on SABC today. But my question to you is not on a legal basis, but on a human basis, given the pain for the people involved here. Why not just withdraw those letters? If you're really committed to now engaging with staff on the structure, on the way the SABC will look, why not just withdraw the letters? They can be issued at a later stage, but maybe the redundancies themselves could change, certainly.
Yes, Francis. So the reverse would actually be true. I think it would be unethical to withdraw letters, give people false hope. We have maintained that the process that we have followed has been fair, it's been transparent. We also engaging with people to say, show us where it can change. And if it makes sense, we certainly will do that as well. But the retrenchment is continuing. It would be wrong for us to do that.
But do you not agree that not withdrawing the letters does suggest you've made up your mind who will stay and go? So any input from staff now can only be sort of cosmetic changes?
Definitely not. So the process is completely transparent, and we will have, for the second part of that, where we're looking at alternatives, will be an independent labor expert that will facilitate those sessions. And we have said that if the structures are going to change at the end of this process, we will execute on that structure. So if there are people that have received letters and they are no longer going to be redundant, then we will withdraw those letters. However, the reverse is also true. There could be additional people that would be now affected, because remember, the unions are also identifying additional positions that could be affected.
All right, thank you very much. Ian Plaatjes, the Chief Operations Officer of the SABC. And we're hoping to speak to Bemawu based on the findings of the Labour Court, talking about how Bemawu approached these consultations. But first, let's speak to one of the other major unions at the SABC. That's the Communications Workers Union. We're joined by General Secretary Aubrey Chabalala. Mr. Chabalala, is this disappointing for you? You had a strategy of Bemawu going to the courts, CWU leading the protests. Has Bemawu let you down in the courts?
Well, good evening to you, Francis, and the viewers. We don't think that Bemawu let us down. Perhaps what we should applaud them for the efforts that they've made. However, on the other day, we'll have to discuss issues of Labour Court and their judgment recently. But ours, we view that as an academic exercise. But we have a strong view that we have moved from the day that we've taken the battle to SABC itself. It moved from the 7 days notice to 30 days. That's where we are. And we have this question of the notice that talks around that they don't want to withdraw the letters, which will mean that the engagement around that particular issue will still be stifling the discussions.
Well, what is your response to what Ian Plaatjes has just said, that it would be immoral to withdraw letters and give people false hope that their job may be saved?
Well, remember, on our side, we still have the right to protest, the right to strike, and the right to engage with the employer. We can hold them with that, but we think that the discussion in terms of the terms of reference that were made regarding this particular meeting will assist us to shape the way forward. But what is fundamental here is about saving the jobs. It's not about the academic that has been made in terms of the judgment itself, but is to arrive at a particular point where we discuss the structure, and we are happy that there will be a broader consultation and involvement of workers, because that's where the key point lies.
Well, where do things stand now? We haven't always been able to speak to you because CWU did declare a strike. So that strike is off for now. Can we say that?
Yes, so what we have said, and there's a letter that we are indicating to SABC to say we want to give the process a fair chance so that we can be able to engage with regards to that process. It does not take away our right to engage back to the industrial action should we anticipate the unwillingness of SABC to engage, or any intention to deliberate a retrench without observing other alternatives that will be bringing about.
Final question. You're obviously not happy with the judgment. I was reading through it, and it looked like the court at least did sort of go through each and every document that was given to the courts, and they looked at what had been given to them, what had been said in those consultations, although no minutes were provided. But there's nothing in any of the documentation that shows that unions put forward an alternative plan to save jobs, something around the structure of the SABC, something about the sustainability of the SABC. Have you really acted on behalf of your members and tried to come up with an alternative given the financial situation of the SABC?
Well, Francis, our inputs were public. You'll know that when we went to Parliament, we presented that page. Perhaps one has to reflect on the courts themselves. I think the court has been consistently reversing the case that workers of this country have been again since 1994, in particularly around 1996 when there was establishment of Labour Relations Act. You'll take into account that today, around Section 197, you can't even consult. They sort of eroded all those rights. So that's why I'm saying that we'll discuss the Labour Court later on. But that's why we firmly believe that the power of workers relies on their labour. When they withdraw labour, that's when the employer can engage meaningfully. But at this point in time, we find this sheer arrogance by people that possess power in terms of economy and capital and all of that. But workers remain with the power of taking it to themselves in terms of labour. So we are very convinced and very focused on what we are doing, and we are not going to be distracted by any judgment at this point in time that has been taken with Bemawu. But we as Communication Workers Union, we are very steadfast that the workers will not be retrenched.
All right, thank you very much, Aubrey Shabalala from the Communications Workers Union, and we're joined by the president of Bemawu, the broadcasting union, Hannes de Busson. Mr. de Busson, this was a rather damning judgment from the Labour Court for Bemawu, I think. You set out to prove that the SABC didn't consult, but the judge found that you didn't consult, and certainly not in good faith.
Yeah, we strongly disagree with the judgment, and we are in process of appealing that particular judgment for various reasons. It is factually incorrect. The judge has quoted sections as part of evidence that was never presented as evidence. So, yeah, we strongly disagree with what he has said. There was no evidence presented, for instance, not an affidavit or otherwise, on the allegation that we did not consult. So how the judge arrived at that decision, it's quite a mystery.
Well, let me read one of the points from the judgment. I must say that this is the judge speaking, that I'm not convinced that Bemawu was acting in good faith for the most part. I agree with the contention by SABC that what was happening in this case was an approach of obstruction intended to delay the inevitable adverse result the disastrous financial position of the SABC would cause. Were you obstructive?
No, absolutely not, and that is exactly what I've referred to, is the fact that no such evidence was presented to the court. There was one line in an affidavit that has made that allegation, but there was no evidence presented that there was obstruction whatsoever, and it is in fact incorrect. We did not. The recordings are there for anyone to go and listen. We did not obstruct the process and delay anything.
Yeah. The court found that your claims that there was no consultation, which we've been talking about for a very long time now, were untrue, basically, and that the consultative process was exhausted. It even looked at what the CCMA had to say. So an outside party said there were consultations. The judge said that even after that, you were insisting on physical meetings with the SABC when things could have been done electronically. You were making claims, basically, my words, missing an opportunity to consult substantively further.
Yeah, that's also not correct. The SABC did not present any evidence of what happened during those consultation processes. There was no minutes provided. There was no transcripts provided. So there is no basis for that, for the judgment or for that particular clause in that judgment.
But
what has happened is...
Why didn't you provide the transcripts?
There is one that's part of the court record. And if there is appetite for that, then we can get those recordings from the SABC and provide that if you're interested in that.
The SABC says you have recordings. Why didn't you give this to the courts to prove your claim that those consultative meetings were hollow, in fact? If you have evidence, why didn't you provide it?
Well, we did in the last the transcript. There wasn't time for us to transcribe everything. It takes quite some time. This was an urgent application. So that was not really the issue. The issue around what was happening and what we took to the Labour Court is the fact that the SABC has conceded. They have conceded that they did not consult on selection criteria. They did not consult on measurements to avoid these dismissal and on severance pay. That on its own should have persuaded the judge that there was no proper consultation, because that is on affidavit. So dealing with what has been in the transcripts and what happened, in fact, it was argued by both parties that that is not really relevant to this application and these proceedings. We are saying the allegation at this point in time is the SABC did not consult on certain issues, like fully on the structure, on the severance pay, and on all of the other issues.
Yeah.
And that was what was actually before the court.
Mr. de Busson, I also saw a claim that Bemawu made concessions about consultations that did happen. So again, I'm just confused. Did you let your members down here by going to the court saying these meetings were hollow, they meant nothing, but providing the court no information, no evidence to prove that?
No, we did not let members down whatsoever. I think that we have, in fact, done quite a lot of extra miles in this process. We went to court because there was not proper consultation. Now, you need to understand what is consultation. Consultation in terms of a Section 189 process is consensus-seeking consultation where parties engage with the intention to reach consensus. That everyone that attended those meetings will tell you that that never happened on the structure. So there was a consultation process that was started off on the structure. So don't be confused about that. It happened. They presented on the 12th and on the 16th the structure. That's common course between the parties. So there was not an opportunity for us to go back to the SABC to say exactly what's happening currently now in this.
to go back to the SABC to say, let's meet with members and let us then deal with all of these structures. That was the agreement right in the beginning, and this is what no one is saying to you.
All right. Thank you very much. Bemawu President Hannes de Besson.